Good evening, everyone, or should I say good day, depending on your time zone, to be inclusive of as many of you as possible. All of you, actually. My name is Rebecca Mignot-Madavi, and I'm researcher in international law in the human dignity and human security in international and European law strand of the Asser Institute. Welcome to the Asser Institute and to this event. Today's event, which is also a book launch, is organized in the context of HILAC, which stands for the Hague Initiative for Law and Armed Conflict. The HILAC lecture series has been organized since 2005 by the Asser Institute in cooperation with the Amsterdam Center for International Law and the Netherlands Red Cross. Greetings to my colleagues who are connected also, I see in the list. Today's discussion will be on IHL and non-state actors, and it's also an opportunity, as I said, to finally celebrate the book co-edited by Ezequiel Heffes, Marcos Kotlik and Manuel Ventura, published by Springer and T.M.C. Asser Press. Of course, we wanted to celebrate this in person a few months ago when the book came out, but the virtual model at least allows us to have with us excellent speakers who I will now briefly introduce to you. I will skip the presentation in detail of their impressive backgrounds, which I am sure many of you are aware of in any case. So for starters, Ezequiel Heffes is a thematic legal advisor at Geneva Co and also PhD candidate at the Grotius Center for International Legal Studies at Leiden University. Marcos Kotlik is an associate legal officer at the International Court of Justice and the academic coordinator of the Observatory of IHL of the University of Buenos Aires. Manuel Ventura is an associate legal officer in the Office of the Prosecutor at the International Residual Mechanism for Criminal Tribunals, and this is for our three co-editors of the book. Ezequiel will give an introduction of the book, and then Marcos and Manuel will join us for the discussion. We also have the pleasure to have with us today Dr. Yasmin Naqvi, co-author of one of the chapters. She is also special advisor to the Deputy Director General of the Organization for the Prohibition of Chemical Weapons, OCPW. We'll refer to it in this way in the conversation. Welcome, Yasmin. We have with us also Dr. Tilman Rodenhauser, who is thematic legal advisor at the ICRC, and Professor Marco Sassoli, Professor of International Law at the University of Geneva and former director of the Geneva Academy of IHL and Human Rights. I want to thank you all for making time in your busy schedules. Ezequiel, before giving you the floor to introduce the book to us, a few housekeeping issues. So we'll start with a discussion with the panelists, and we will then dedicate some time in the end for interactions with you, the audience. So just know that you can already share with questions and type them in the chat. And I will make sure to be your voice and make sure to share as many of your questions as possible in the end with the speakers. Ezequiel, Marcos and Manuel's, congrats to you again on the publication. Ezequiel, I give you the floor for the introduction of the book.
Thank you very much, Rebecca. And well, first of all, I'd like to thank the Asser Institute for hosting this book launch. It is highly appreciated, and obviously a big word of appreciation for the people who have accepted to speak today, Yasmin, Tilman, and Marco, and for you to moderate the event. It is definitely our pleasure to have you today speaking about non-state actors and international humanitarian law. And also, I'd like to thank Asser Press and Springer for all the help during the process of publishing this book, which it was a bit lengthy, but we would like to express our words of gratitude to Frank and to Kiki and all the people behind the curtains. So a few words on how the conception of the book are in order. So a couple of years ago, I would say it was maybe 2015, 2016, I was working for the ICRC in Afghanistan, and Marcos was working doing IHL research at the University of Buenos Aires, and Manuel was working in international criminal law in The Hague. And we were having some discussions between us about how the role of different non-state actors, the role of different non-state actors in the IHL realm. And so, for instance, we had realized that different non-state actors, there were different interactions between non-state actors that were taking place in different levels of formality and informality. So, for instance, I was at the ICRC, and you know, obviously you talk to states and to state armed forces when you are in different field missions, but you also talk to non-state parties, and you also talk to different UN agencies, UN bodies. You talk to local leaders, community leaders, religious leaders. You talk to different international organizations, humanitarian actors, Doctors Without Borders, human rights organizations. And the same was happening, the same type of reflections in terms of these interactions were happening on Manuel and Marco's side. So we had started having discussions about this in maybe in 2015, 2016. And we realized that there was kind of a gap in the literature, specifically dealing with non-state actors and international humanitarian law. There had been some studies about non-state actors and international law before, different books, and also the International Law Association having a group on this. And of course, there was a big and important book on human rights and non-state actors by Andrew Clapham. And people working on different non-state actors, specific non-state actors. So of course, individuals and members of international organizations working on UN bodies and international humanitarian law, working on non-state armed groups and international humanitarian law, private military and security companies and international humanitarian law, and of course ICRC, other humanitarian organizations, how they would interact with humanitarian law at different levels. But there was no comprehensive study on this. So at the time, because of our different jobs and different positions, we had the need to actually to put down an edited volume. And this is why it is an edited volume, because we had the impression that we needed to bring voices from different non-state actors when working in the IHL realm, and also putting them together with some scholars and members of academia, and have this discussion on the role of non-state actors in the international humanitarian law sphere. So this is why this book is an edited volume, and you'll see that it combines people working from ICRC, Geneva Call, UN, people working in academia, people working in, I mean, when I say UN, I say different bodies, and it's very good that we have Yasmin as well later, and we have Tillman, and of course we have Marco with broad experience, people working on from a state perspective with non-state actors such as private military security companies and the International Court of Justice. So the idea was kind of to bring people from different spheres and to have a discussion about this. And it's interesting because we, in the process of reflection and discussions among the three of us and with the authors, we gave absolute freedom to the authors to actually move around as they felt. And we came out with different conclusions from the chapters, and these are included in the introduction of the book. So we kind of like felt that there were four dynamics that were represented in the different chapters of the book. So the first one is that there is a proliferation of non-state actors, and of course there is a proliferation of non-state actors in the international law realm. It's not only in the IHL sphere. So there is a proliferation, and there has been a proliferation in the international legal realm for, like, I would say 30, 40 years. I mean, we see now many more non-state actors interacting. So for instance, in the IHL sphere, we see more NGOs dealing with IHL. I mean, since probably even since 1990s, we see human rights NGOs dealing with IHL. We also see different UN bodies and institutions dealing with IHL, newly created institutions that were developed in the last maybe 20, 30 years. Other types of NGOs, Geneva Call, for instance, was created in the 2000s. We see also a fragmentation of non-state armed groups, and this has also been confirmed by recent studies by the ICRC. So we see, of course, we have international criminal tribunals since the 1990s dealing with international criminal responsibility of individuals. So we see a proliferation of non-state actors dealing with different different issues related to IHL, enforcement, application, issues such as respect. So this is the first dynamic that we have identified, and we see that chapters dealing with armed groups or the International Criminal Justice, the International Court of Justice, I'm sorry, or international criminal tribunals, private military security companies, ICRC. So we see that there is an increasing intervention of these non-state actors in the IHL realm in the last 30 years. The second dynamic that it actually comes from the chapters is that in the last 20 or 30 years, there is an increasing discussion on the rules applicable to these non-state actors, even beyond the IHL sphere. So, of course, traditionally, one would say, yes, we have IHL, and we have, for instance, when we deal with armed groups, the classic example is we have Common Article 3 since 1949, Additional Protocol 2, customary IHL. But in the last, maybe in the last 20 years, there has also been some discussion about other legal realms applicable not only to armed groups, but also to other non-state actors. The development of international criminal law as well by international criminal tribunals that are by nature non-state actors. So we see a development of I would say, new rules of pushing the boundaries of international law with respect to these entities. The third development is, and I'm going to repeat here, is the development of IHL by certain non-state actors. And when I say development, I mean not only because a classic and positivistic approach of international law would say that we have, treaties can only be created by states, customary law only takes into account the practice of states and the opinio juris, and then we have the general principles that as the main three sources of international law, as included in the statute of the International Court of Justice. But in the last few years, we see non-state actors dealing with the development of international humanitarian law as well. We see, for instance, and I know that this is going to be discussed later, but we also see issues such as human rights bodies dealing with the application of international humanitarian law. We see the International Court of Justice dealing with these issues. I mean, even saying that certain provisions of international humanitarian law are customary in nature. So we also see the role of international tribunals identifying customary law. On the last one, and with this, I'm gonna give the floor to the speakers who they're gonna say very interesting things, is the horizontal interactions that we see among non-state actors. So a traditional way of seeing, I would say, the relation between non-state actors or actors and any legal system is kind of in a vertical way. So we would analyze the application of the law to that specific entity, to states or non-state actors. But what we have seen actually is that several chapters deal with the interaction of these non-state actors. So, for instance, we have chapters dealing with how the ICRC engages with non-state armed groups in order for them to increase their level of compliance of humanitarian law. Geneva Code as well. We also see human rights bodies dealing with these issues, such as the special representative, the mechanism on children and armed conflict, the special representative on children and armed conflict that signs action plans with states and non-state armed groups on child protection issues. So we see suddenly that there is an increasing interaction between these non-state actors without necessarily the state being part of it. So of course, one could say that states they provide the financial support to some of these non-state actors, but still, when some of these non-state actors sit down and discuss about international humanitarian law, about enforcement, application, issues related to compliance, there are no state representatives in those discussions. So this is the fourth dynamic and that we have identified from the book. It was a very challenging and interesting endeavor because, again, the authors and who actually we should also be thankful for, because they were always during the process very open to have discussions and exchanges with us about these issues. So the process was an interesting one, and we're very happy to be here today sharing the findings. And Yes, with that, I think I spoke already the 10 minutes that I had. And again, thank you very much for the time that everyone is sharing with us.
Thanks a lot, Ezequiel. I think it's a great sharp summary of the book's finding, and great to start the discussion. So in light of the book's intention and findings on the increasingly prominent role and increasing attention also given to non-state actors, I would like to start the discussion maybe with Professor Sassoli, and in exploring what the difficulties can be in treating non-state actors like states, let's say, in international law, and what is the specificity of armed non-state actors in that regard. If you could share with us a few reflections.
So thank you very much. Congratulations to the editors to have brought together a book with very interesting contributions. I will indeed focus on armed non-state actors, not only because this was always my preferred subject, but also because I have frankly to say, to call the International Court of Justice a non-state actors with judges who are elected by state and decide on a case which is submitted by states, and all this is based on a treaty which has been adopted by states, I must say, and the same thing is to a certain extent true for human rights bodies. I see your point, but the common point between armed groups and the International Court of Justice and the Human Rights Committee, I must say, is only at a very high level of abstraction. And obviously the armed non-state actors are, in my view, nevertheless, the greatest provocation to the Westphalian concept and to states. Now, just to play the devil's advocate, I would nevertheless, also I'm very much with most of you, those who wrote about armed non-state actors, that criticizing states that they try to ignore non-state actors, while in particular for humanitarian law, it is the new frontier and it is the greatest challenge. The armed non-state actors, we have to admit that there are some problems. One is that the monopoly of the use of force according to the Westphalian system, it has also a humanitarian value. I mean, the fact that only the state may use force and not every one of us against every one of us, and that there are no more feudal lords with little castles around Europe, for instance, or in China, the warlords, is an advantage for the inhabitants of China or of Europe. And then also one has to be nuanced. I would say nearly all states are more representatives than nearly all armed non-state actors of a population. I mean, they represent the population, while at best, non-state actors claim to represent the population. Perhaps, as I'm speaking from Switzerland, I'm too much obsessed by democratic legitimacy and not something higher of natural law legitimacy. And governments, nevertheless, most governments have to arbitrate between competing interests. And then there's a problem that states simply do not want armed non-state actors. It is mainly academics and experts who want to integrate them, and I think rightly so, but we have to face it. You know, the article written in your book by Anne Quintin and Marie-Louise Touga, they very diplomatically mention that both recent initiatives to develop IHL or to discuss or clarify IHL, both on an implementation mechanism and on detention, where the idea to integrate non-state actors, or even to speak about detention by non-state actors, which is a reality, and I'm with you that we have to deal with it, but states, this was a no-go for states. And I have made a personal experience concerning human rights law, and also I agree with everything Jean-Marie Henkertz writes about human rights bodies more and more addressing themselves and dealing with non-state actors. When I was director of the Geneva Academy, we tried to initiate a process where non-state actors, the views of non-state actors and the obligations of non-state actors under human rights law could be dealt with in one way or another in the Human Rights Council. And I have to tell you, there was only one state who was open to this idea. Only one state. We didn't succeed to find a second state. So unfortunately, there is still a lot to be done. And finally, something perhaps more technical. We have to admit that as there is no jus ad bellum internum, and I think this is one of the greatest lacunas in international law today, jus ad bellum and jus in bello have to be separated. I agree with that, obviously. But as we don't have a jus ad bellum, to deal only with the jus in bello with non-state actors is somehow more problematic, and I think we should deal, and some in the book mentioned that we should try to find the jus ad bellum internum, but here again, states would never want that.
Thanks a lot for these reflections. So could we maybe challenge the idea that states do not want non-state armed groups? So with the evolution of direct participation in hostility as continuous combat function, for example, isn't there a temptation for states to go closer to an armed group characterization for these transnational non-state armed group in order to extend the scope of possibilities of targeting possibilities, for example? So to what extent is that true? You know, you try to challenge your view yourself. To what extent is that true that states do not want armed non-state actors?
No, you are right. States, I call them always schizophrenic, because on the one hand, they want to find a possibility to give obligations to armed non-state actors, and on the other hand, they want not to speak about them and not to mention them. And I mean, one of these schizophrenic products is Protocol Additional 2, which simply is always the substantive obligations are formulated in the passive tense, because if you were, which everyone tells you, if you want to give people obligations, don't put passive tense, but put the addressee. Even my granddaughter, I have to tell you, you must do that, and not it must be done. But states didn't want to call them because they believe that if we mention them, they already get a legitimacy and they will disappear if we close our eyes about it. So you are absolutely right. And we can hope that this schizophrenic attitude will disappear. I mean, even in these discussions I mentioned about the Human Rights Council, I mean, several states in the Human Rights Council criticize special procedures, that they only criticize states involved in a non-international armed conflict and not the terrorists and so on. But if the special procedure addresses armed groups, then precisely those states get very upset. So it's a difficult thing. I'm not sure that we are developing in the right direction. Sorry that I'm pessimistic, but rather I have the impression that states become more reluctant, also because of this whole terrorism nebula around it, and somehow every armed non-state actor is obviously for the state against which it fights a terrorist.
Mm-hmm. So moving now to the question of lawmaking process and how non-state actors appear in the picture, in this picture of lawmaking processes, and specifically armed non-state actors. So I know that you have expressed support for the practice and opinio juris of armed non-state actors should be taken into account when determining customary IHL of non-international armed conflicts, but you are also aware of the difficulties it can pose. So could you expand a bit on those for our audience?
Yes, thank you very much. Well, there again, I want to be a little devil's advocate, because indeed I'm convinced that it is the very nature of customary law that it is practical and realistic. And if we want to be realistic in non-international armed conflict, we have to deal with both sides. And therefore it must be based on the practice and opinio juris of both sides. So I remain convinced of that. But I must admit there are some difficulties, and all of us until now, somehow here we are like states that we try not to mention the difficulties because it could undermine our aim, which is that indeed such practice is taken into account. One problem is obviously that, at least in my view, an armed, I call them armed group. An armed group exists only if there's an armed conflict. And this is a classification issue. And therefore, before we can say this armed group, we take its practice into account, we have to classify the situation as a non-international armed conflict. And so, I don't know, drug gangs in the favelas, their practice would not be taken into account because they are not parties to an armed conflict, at least in my view. And next, obviously, then there would also be the question whether a conflict is international or non-international. You know, the question of whether they are under overall control of an outside state and all these things. Next problem is whose practice counts in non-state actors, which are less and less, or less frequently, hierarchically organized. And I don't think you could simply say every member of a group contributes to customary law. Just as for states, we don't say every citizen or even every public official contributes to customary law. So we would have to clarify who contributes to customary law within an armed group, which is particularly difficult in those decentralized, frequent armed groups today. And then there's a problem that states are meant to be permanent, while non-state actors, armed non-state actors, sorry, not the International Court of Justice and not the International Criminal Court and not the ICRC, which nevertheless is more than 150 years around. But armed non-state actors are meant not to be permanent because they want to win and then they become a government of a state, or they lose and they are no longer around. And this is a problem because to determine customary law, we need nevertheless a minimum of permanence and stability. And states are repeat players and may in many fields have practice versus many different states, while normally, okay, there are exceptions, but normally an armed non-state actor is only fighting one armed conflict and therefore has practice only towards one partner. And in addition, what enriches customary law is the fact that if I claim this is a rule of customary law, then you must also I must also respect it towards you. While non-state actors are often in a situation where they can only be beneficiary or only addressee of the rules, say on governments have less problems with suicide attacks, but more problems with drone attacks. So there is no symmetry, which is often important to create customary law. And non-state actors are much more different than states. So we probably would have either we come to the conclusion that there is a common minimum denominator, which would be very limited for all armed non-state actors, or we would have to create, I don't know, 10, 15, 20 categories of saying armed non-state actors, de facto authorities, those that control government, which is not always a de facto authority, those which have a political aim, those who are hierarchically organized, and so on. And so would that mean that we end up with very different customary regimes for different kinds of non-state actors? Now, obviously, I'm the first person who says, yes, but states are also very different. But at least in the last 150 years, there is the fiction that the Marshall Islands, Liechtenstein, and China are similar for international law, which is much less the case for non-state actors. And then there's a problem that we have to clarify whether this customary law, based on the practice and opinion juris of non-state actors, will create or contribute also to the customary law addressed to states, or only for the armed non-state actors. And this is a serious dilemma. Because on the one hand, it would mean that the equality of belligerents is somehow abandoned before IHL, which would be a very delicate step. Or on the other hand, why should a state have less obligations because the armed group is very little organized, and therefore even if it really wants to comply with IHL, its practice will be very limited in terms of especially positive obligations under humanitarian law. So you see, I think this is something which, and it is not a criticism for your book because you cannot do everything, and I know that several of the editors work on these issues, but I think we have to face it. And so the next book perhaps should be on these issues, because I think now we are at a step where many people agree with this basic idea that there's no sense to have a law of non-international armed conflict if we don't get armed non-state actors in. But now we should go to the next step, which is to say, and how do we do that? How could we do it? Let's assume that states, which they do not for the time being, accept that armed groups can contribute. Well, how could this work? Thank you.
Thanks a lot. This is a fantastic food for thought. We already have a preface for volume 2, Ezequiel, Marcos, and Manuel. And I think it's a great transition, actually. Our last topic, I suggest we move on to a case study, let's say, of these broader challenges of lawmaking, but also of how we treat non-state actors, armed non-state actors in contemporary IHL, with the question of whether there is a credible customary law prohibition of use of chemical weapons for non-state actors with Dr. Nakvi, who authored one of the chapters of the book on the topic, together with Olufemi Elias. So Yasmin, in this chapter, you offer really a really rigorous and critical analysis of the state's assumption that there is such a thing as customary international law prohibition of the use of chemical weapons for non-state actors in any circumstance, peace and wartime. So maybe we can start from what could appear at first glance as the most straightforward aspect of this assumption, which is the prohibition for non-state actors to use chemical weapons during armed conflicts. So can you tell us a bit about what IHL treaties say on this and how IHL in this sense treats non-state actors?
Yes, and first of all, let me also add my congratulations to the editors of this very impressive volume, super interesting contribution to this area. Just as a preface before I answer your question, to give you context into this question of chemical weapons and non-state actors, I remind the audience that it has been said that biological and chemical weapons are the poor man's atomic bomb. And that rather alarming statement is true because to make nuclear weapons, you need very specialized capabilities and materials, which are very hard to get your hands on. Chemical weapons, on the other hand, are cheap and easy to build using equipment and material that are readily available because they also can be used for a whole host of legitimate purposes. And non-state actors have shown that they can make and use sarin, as was done in Tokyo in '95. They can make ricin in their kitchen and send it in the mail, as was done quite recently in the United States. They can make sulfur mustard, and this was done very recently also in Iraq and Syria in the past years. And so indeed, as you said, in response to this very real threat, the international community has unanimously responded in a host of different international fora and condemned the use of chemical weapons by anyone in any circumstances as a violation of international law. And that seems straightforward, but in fact, when you look at that statement, it's not immediately apparent what the legal basis is of that statement, because beneath that statement is quite a complex legal picture. So turning to your question on IHL treaties to begin with, Femi and I looked at the historical evolution of the ban on chemical weapons. And going back right to the beginning, the very first agreement that can be said to be regulating chemical weapons is the 1675 Strasbourg Agreement, which banned the use of poison weapons. This was still more or less equivalent to being something applicable to an international armed conflict. Similarly, the Brussels Declaration of 1874, which prohibited the use of poison and poisoned weapons, and the use of materials causing unnecessary suffering, would apply only in international armed conflicts and during occupation. The Hague Declaration on asphyxiating gases of 1899 required states parties to abstain from the use of projectiles that would diffuse gases. And the Hague Regulation of 1907, which prohibited the use of arms which cause unnecessary suffering, again was applicable to international armed conflicts. Again, the 1925 Geneva Protocol was limited to the application of international armed conflict. So non-state actors were not directly bound by that protocol. As you probably know, the Geneva Conventions of 1949 do not have any prohibition of chemical weapons or other types of weapons. The one limited exception, perhaps you could say, is that non-state actors would be bound by the prohibitions in Common Article 3. So if the use of a chemical weapon violated those prohibitions, there could be said to be a violation there. Additional Protocol 1 of 1977 didn't specifically ban the use of chemical weapons, although it does prohibit the use of weapons which cause superfluous injury and unnecessary suffering. And there is little doubt that that prohibition would cover the use of chemical weapons. And you can see the commentary to the ICRC commentary to that, which affirms the fact that it was those types of weapons the drafters had in mind when they encapsulated that principle. Now, what's notable about the 1977 Protocol 1 is that, of course, it does only apply to international armed conflicts, but the definition of international armed conflicts is expanded to include those types of fights against, well, in the exercise of self-determination. So at least in those types of conflicts in those states which have ratified the protocol, you could say that the non-state actors fighting for those types of struggles would be bound by that prohibition not to cause weapons causing unnecessary suffering. And the additional Protocol 2 contains no prohibitions on the use of weapons. Then in later 1972, the Convention on Biological and Toxin Weapons would cover chemical weapons to the extent that it covers toxin weapons. But that convention doesn't directly prohibit the use of such weapons, and is also binding on states parties only. And similarly, the Convention on Chemical Weapons adopted in 1993 is binding directly on states only, although it does require states parties to ensure that they have criminal legislation which is applicable to anyone in their jurisdiction, and also that they could extend extraterritorial jurisdiction to their nationals who commit any prohibitions of the convention in another territory. So as you can see, international treaties actually don't really provide much of a basis for this statement that under international law, non-state actors are banned from using chemical weapons. And yet what we see is that the ICRC, for example, in its customary international law study, the Rome Statute of the ICC, both provide support for the view that it is a war crime, both in a non-international armed conflict and an international armed conflict, for anyone to use a chemical weapon, or at least in the words of the ICC statute, the poison and poison weapons and asphyxiating, poisonous or other gases. So if you assume that that position is correct of the ICRC and that the Rome Statute's war crimes provisions covering chemical weapons are reflective of customary international law, that still leaves the question of what international law is then violated by the use of chemical weapons by non-state actors at any time outside the context of an armed conflict. And to answer that question, we had to look at other sources of international law and practice.
So that would be actually very interesting if you could expand on this at a later point, maybe. But can you also share with the audience how the Chemical Weapons Convention treats, if at all, and I'm a bit killing the suspense here, non-state actors, and some reflections on the role of the OPCW's policymaking organs, and the role that they can or do or should, even if the normative level is maybe less addressed. It's not the purpose of this paper in particular, but if you have also some views on the role that in your view should perform and can perform to address the use of chemical weapons by non-state actors, that would be, I think, super interesting.
Yeah, so as I mentioned, the Convention on Chemical Weapons, it bans the use of chemical weapons by the states parties directly in Article 1, and it has a very broad prohibition, so not just on use, but development, production, transfer. And it has a very broad purpose, the convention, which is stated in the preamble, to exclude completely the possibility of the use of chemical weapons, which in itself suggests that it would be perhaps anyone using chemical weapons. But by the actual specific provisions of the convention, there is no direct binding prohibition on non-state actors. It does not, unlike some international treaties, establish the use of chemical weapons as an international crime. Rather, so the states parties are required under Article 7 to enact domestic legislation. And that will prohibit any natural or legal persons on their territory from undertaking those prohibited activities. And as I mentioned, they also need to establish extraterritorial jurisdiction for their nationals. So what you see in the convention is that most of the provisions are concerned with dismantling large state-owned chemical weapons programs. Nonetheless, there are a few provisions within the convention which suggest that non-state actors are also prohibited from using chemical weapons. So, for example, states parties are not obliged to assist, encourage or induce anyone to engage in any activity which is prohibited to a state party. States also have to put in place measures to ensure that non-state actors cannot acquire the means to use chemical weapons. States parties can request assistance and protection from the use of chemical weapons regardless of the perpetrator. And that type of request can trigger an investigation into alleged use by the OPCW or deployment of the OPCW's Rapid Response Assistance Mission. And in addition, OPCW experts can be requested to assist the United Nations in an investigation of use of chemical weapons in a territory not controlled by a state party. So that could mean on the territory that is controlled by a non-state actor. So the convention does have this certain scope for being able to indirectly suggest that there is this prohibition on non-state actors. But what is interesting, as you mentioned, is to look at, well, what is the implication of that for customary international law? And one way to look at it is to say, well, we know that certain conduct in a treaty can give rise to international criminal responsibility under customary international law. So in theory, the prohibition of the use of chemical weapons in the convention may attract international criminal responsibility. And then you really have to look at, but is there enough state practice or opinion views to support that? And we looked at, first of all, the practice of states parties who are party to the convention, which, by the way, is nearly universally ratified. So if you're looking at state practice through the guise of an international organisation, it's more convincing when you can look at a treaty which is almost universally ratified, or where there is an organisation that has almost all the membership, in order to really see, is this something reflective of state practice? And luckily, in the case of the Convention on Chemical Weapons, almost every country in the world except for 4 are party to the convention, which makes it quite convincing. And what that practice shows us is there has been repeated affirmations that anyone under any circumstances cannot use chemical weapons, and that any such use of chemical weapons by anyone should be investigated, and there should be accountability for that. And that has been, so you can see that not only have you got this widespread state practice of criminalising the use of chemical weapons by anyone on their territory through the domestic legislation requirement, you've also got that together with all of these statements of the Executive Council, of the OPCW, of the Conference of States Parties, of regional statements, of individual states, making that same statement that it is any use of chemical weapons by anyone under any circumstances would be a violation of the standards of the international community. They don't come out right and use the words international customary law, but they do use the term, the standards of the international community. And it provides quite strong evidence that that is what they understand to be international customary law.
Yeah, that's actually very helpful to see the gap between, as you say, rhetorics and the actual stage of evolution of customary international law. And this, I'm sure, will provide great food for thought for discussion afterwards. And maybe to follow the voyage, you're really bringing us step to step in different forums and in a very, as I said, very analytical and rigorous way. So maybe to reach this holistic understanding that you reach yourself in your paper, maybe you could end up by sharing with the audience some of your findings on how the UN Security Council and the General Assembly, but also some counter-terrorism treaties deal with the topic, if that's okay.
Sure. So the UN Security Council's resolutions also arguably provide evidence of opinio juris and state practice, which is relevant to this question. So although there's only 15 states in the Security Council, given its role as the principal organ of the UN responsible for the maintenance of international peace and security, as well as its lawmaking power under Chapter 7 of the Charter, its resolutions can, in some circumstances, contribute to the identification of customary international law. And with regard to the use of chemical weapons, the UN Security Council resolutions have been consistent with that other practice that I mentioned of the OPCW policy-making organs, as well as the UN General Assembly. And it's that convergence of practice that really provides more weight to the proposition that this is a reflection of international customary law. So the Security Council resolutions begin really with the resolutions that began to be passed in the 1980s with regard to the use of chemical weapons in the Iran-Iraq war. And they eventually led to the establishment by the Security Council of the UN Secretary General's mechanism to investigate uses of chemical weapons. And what's interesting about that development is that even though the context was an international armed conflict, the resolution establishing that mechanism went much further than that context and actually required there to be investigations of the use of chemical weapons in violation of international law by whoever and wherever committed. That idea has been further solidified through resolutions that were passed after 9/11, when you had first Resolution 1373, which talked about the threat by non-state actors getting possession of weapons of mass destruction and how states should start to coordinate and talk to each other. Stronger obligations were established in Resolution 1540, which specifically dealt with the threat of non-state actors and weapons of mass destruction. And it required the states to the UN to adopt and enforce effective measures, effective laws, which prohibit non-state actors from manufacturing, acquiring, possessing and using chemical weapons, as well as financing those types of activities. There have been a number of resolutions since then related to specific terrorist groups, such as ISIL. And finally, in 2015, the UN Security Council established the OPCW-UN Joint Investigative Mechanism, which has had as its purpose to identify the perpetrators of chemical weapons attacks. And the Joint Investigative Mechanism ended up releasing a number of reports, including some conclusions that ISIL used chemical weapons on 2 occasions in Syria. So the General Assembly resolutions have also been pretty consistent on this point. In relation to Syria, perhaps most significantly in recent times, the General Assembly established in 2016 the IIIM on Syria. And in that resolution, it also mentioned the Joint Investigative Mechanism, suggesting that chemical weapons would also be within its mandate. In terms of international counterterrorism treaties, There are a number of obligations within those treaties which are relevant to the use of chemical weapons by non-state actors. So, for example, the 1997 Terrorist Bombings Convention requires states parties to prosecute or extradite any person who is present on their territory who has basically used a bomb-type device which releases toxic chemicals or toxins. And then you have the Financing Terrorism Convention, which requires states to criminalise financing acts which are prohibited by the Terrorist Convention. There's also the 2005 Protocol on the Convention of Unlawful Acts on Maritime Navigation, and also the 2010 Convention related to international civil aviation. Now, what the interesting thing about all of these conventions is that they actually apply mostly to peacetime. So they provide additional relevant practice demonstrating that the use of chemical weapons by non-state actors in all circumstances is a violation of international law and has criminal consequences.
Thanks a lot for this. I would have more questions for you, but I see that also in the audience you have questions related to accountability mechanisms, etc. So I will leave it for the Q&A, and I think it's a good point to emphasize that both you and Marco and these presentations also talking about terrorism, and maybe it can lead to a discussion on the specificity also of transnational terrorist groups in exacerbating maybe the challenges posed to IHL. But before that, I want to move on to taking a different perspective together with Dr. Tilman Riddenhauser. Tilman, and it's related to my previous point. So although we can see that already in the two first bits of discussion that we've had, the inclusion of non-state actors in the academic debate in IHL is, let's say, recent in the scale of things, intensified with the growing importance of transnational armed non-state actors, maybe, as I mentioned. The ICRC has a long history of engagement with a variety of non-state actors. So can you tell us a little bit about this, about the ICRC's practice in this regard, but also about how, in your view, the book this practice?
Thank you very much, Rebecca. First of all, well, let me thank you for inviting me to the seminar, to this book launch. I'm very happy to be here. And first of all, I need to congratulate Ezequiel, Marcos, and Manuel for the completion of this book project. And I must say, I'm really happy, actually, and proud to see three young scholars having the courage to put together such a book with very interesting and high-level contributors, both from the academic and from the practical field. I think that's the real value of this book. Now, with regard to your question, do the different chapters of the book reflect what the ICRC has seen and experienced in the past decades with regard to non-state actors? I would actually say that especially the first three chapters, they are spot on. We see non-state armed groups, we see private military and security companies, and we also see the UN all as actors or as non-state actors that are relevant and involved in armed conflicts. And let me maybe briefly touch upon at least two out of these three, or maybe all three of them if you have time. The first one, and here I would concur with Marco, the most prominent and important one among these non-state actors are non-state armed groups. And as Marco and also Ezequiel said before me, they are reality of most of the conflicts that we have today. In recent years, the ICRC has been engaging with over 400 armed groups around the world in different conflict and other settings of violence. Why do we do it? There's mostly two reasons. And the first one is to protect affected populations by ensuring that non-state armed groups operate in accordance with international humanitarian law and do not harm the civilian population and also soldiers that find themselves hors de combat. The second reason is actually quite operational. For the ICRC, if you think about how we can access territory in which these groups operate or which might be held by these groups in order to reach the populations that are there and to provide both protection and assistance activities, we need to we need to be known by these groups, we must be understood by these groups, so we need to engage with these huge variety of groups. If you want more detail about what the ICRC has been doing over the past decades in that area, I think the contribution by Anne Quentin and Marie-Louise Tugat in the book is quite comprehensive. But I must also say that I really appreciated reading the contribution by Jean-Marie Henketz and Cornelius Wiesner on human rights and armed groups. And of course, we also see the challenge that Marco raised, that this is a very challenging topic and is not one that receives great enthusiasm by states. But we also see that we have a reality where we estimate that between 60 and 70 million civilians, people, live under the exclusive control of non-state armed groups. So under the exclusive control, where the state is no longer there to ensure respect for human rights, to facilitate human rights. And here, of course, this question of, are there others that might have human rights responsibilities or even obligations gets a new dimension, gets a very real and not only an academic dimension. And the same to some extent holds true with regard to detention by non-state armed groups, which I think is touched upon in 2 chapters actually. Here we see over 100 groups in the different operations or different contexts where we operate that hold detainees. And again, this is a very practical challenge and where we think more thinking and more work is needed. And as Manuel Ventura, one of the editors, but also a contributor to the volume, as he points out, we need to look at how non-state armed groups can actually implement the legal obligations that IHL imposes on them. The second group of actors that I would briefly say a few words about are private military and security companies. They are, again, I would say in the past years, they have been quite a prominent occurrence in a number of armed conflicts. Think about Syria, think about Mozambique, Libya, Central African Republic. And why they also fall into this larger group of non-state actors, they're quite different from non-state armed groups because often these private military and security companies, they operate alongside states. They operate on behalf of states and not as non-state armed groups would do, that they usually oppose the state. When we look at armed groups, what I also find quite good in the chapter that we see, and which is a reality that we of course also observe, is that these private military and security companies are very broad spectrum. You have those that only provide logistics, that perform a lot of functions that the militaries outsource to them. So it's a lot of military base management. Then you have a certain type of contractors that work in the management of weapon systems. So often new weapons of warfare, if they're very sophisticated, they might come with their contractors. So you buy them and you get the contractors contracted with them. But then you also have those companies that actually are hired and that are engaged for fighting the conflict. And I would say this latter group is the one that is really important with regard to IHL and also with regard to potential humanitarian consequences that these actors cause. And I mean, one aspect on that, on the legal framework around them, is that when the use of these companies became more prominent in the years 2000, especially in Iraq and Afghanistan, the international community reacted, and you had, led by Switzerland and by the ICRC, you had a process that led to the development of the Montreux document on PMSCs. And in that document, you find a clarification of how international law, most notably international humanitarian law, applies to their operations during armed conflict, but also a set of good practices of how states can actually enforce and implement that. And that is a document, and there have been other initiatives around that go in the same direction. And that's something which is very well reflected by Martina Gasser, who's also involved in some of these processes in the book chapter. But there's one challenge that makes the whole issue more difficult. And that is that these companies, when you look at media reports and how they're used in different conflicts, it seems to suggest that often they are hired when states do not want to themselves take responsibility for the operations that these actors are hired for. And if that is the case, if the state wants to operate with plausible deniability and not take responsibility, then also that whole approach of using the state as a regulator of these companies will probably not be as effective. as effective. I could also say a few words about the UN, but maybe in the interest of time, I can spare that. If someone's interested, I can make them during the discussion.
Okay, thanks a lot for this response. Very interesting response. Indeed, maybe we can touch upon another issue and leave the UN for the discussion. So, given that the majority of current armed conflicts, as was mentioned in introduction, are non-international armed conflicts, and thus involves non-state armed groups, what does the ICRC's work of confidential classification of situations involve? If you can say a few things about this, and how does the ICRC gather information and assess criteria under Common Article 3 and Article 1 of AP2? If you can share a few thoughts on this with.
That's of course a very good question, but maybe let me start by just rephrasing it slightly. Why do we classify conflicts? And for the ICRC, conflict classification is essential because it determines whether or not the situation amounts to an armed conflict. And we need that clarity in order to afterwards engage with all parties to these situations of violence and then to these conflicts on their legal obligations. And this is quite significant because there is a stark difference, for example, in the use of force, on the rules of the use of force between, on the one hand, a situation of peace, and on the other hand, a situation of armed conflict. So there's a significant difference in the rules that apply. So for that reason, it's important, but also operationally for us, the legal basis on which we offer our services and how we have access to, or how we can ask for access to affected population also depends on the conflict classification. So this is something which is very relevant for us from for different reasons. How do we classify? I think legally we use the same criteria that are used by international tribunals, by states, that IHL actors, IHL experts agree on. So we look at the intensity of the confrontations between the parties, and we also look at the organization of the non-state armed groups. But I would think, or I would say where it's really, or where it's special also for the ICRC, how we do that is that in most, well, you need to find the facts and apply the facts to the law, or the law to the facts. But the particular importance is that in most situations, the ICRC is present in the context of violence take place. So we will witness firsthand what is the intensity of the conflict. And we might also have already before the conflict access to the armed actors involved, to the armed groups involved. So we might know from discussions and from experience with them of whether they are sufficiently organized to be parties to armed conflicts. So here this finding the facts is something I would say quite special. And then, of course, we do not, given that we do the conflict classification primarily for our own purposes, we don't systematically publish them or publish a list of what situation we classify or which we don't classify. Also because we simply don't classify every conflict in the world. We classify those conflicts which are operationally relevant for us. But if someone wants to have a hint on what the ICRC considers to be an armed conflict and what type of armed conflict, you often find in press releases and statements, you find, for example, you find a call by the ICRC on all parties to armed conflicts to respect IHL. And that call, of course, would only happen in times of armed conflict. When we look at current trends or current challenges, because I must say, it's a fascinating task legally to classify a conflict. It's complex, but it can also be very interesting. But often I also don't envy our colleagues because the realities that we see become more and more complicated. We have an exponential increase in the number of armed groups. There have been some contexts where analysts have spoken of hundreds or even thousands of armed groups being involved in the same country in one situation of violence, and classifying all of that poses very significant challenges. And for the lawyer involved, I would say some of the really intriguing ones are, for example, if we have various small armed groups and they then unite under one umbrella organization, at what point can you say that this umbrella organization with its different components in a bit of a horizontal organization that Marco also mentioned, when is that one organized armed groups for the purpose of IHL? It's a challenging question where you don't find the answers in the treaties. The same is the case when you have also a number of armed groups, but they don't have an umbrella organization, but maybe they fight alongside each other against a common enemy. Here again, the question is, how do you assess that situation legally? And here I can recommend to everyone a recent blog post by three of my colleagues who regularly do these classifications. It's last month. It was published on the ICRC blog. I can really recommend reading it. Maybe as a last challenge, we don't only have coalitions of armed groups, but we also have a splintering of armed groups. So you have armed groups splintering in 2 factions or multiple factions. And again, the question arises, are they now all parties to a new armed conflict or separate armed conflicts, or are they maybe no longer parties to armed conflict? So these are challenges in which we find relatively little guidance, for example, in Common Article 3 or Additional Protocol 2, and only some practice. And so we have to work through and interpret IHL in order to address these situations.
Thanks a lot, Tilman, for these very stimulating reflections. In conversation with Marco's and Yasmin reflections before, how do you see, and building on what you just mentioned, actually related to the classification of conflicts, how do you see the future of non-state actors in the realm of IHL? So how do you see this evolving? I don't want you to look at a crystal ball here, but how do you expect also the evolution of the interpretation of IHL in that regard? Do you see state centrism being winning, let's say, the interpretative battle, or how do you see both the practicality of IHL and non-state actors evolving, but also the interpretation of IHL in light of this practical evolution?
Well, thank you. And I'm always a bit, or to me, this question of state centrism, I don't always understand it completely. Of course, international law has this, as a law of nations or former law of nations, international law has this state focus, but the reality of armed conflict is that we have this immense number of non-state armed groups that as a humanitarian organization, we have to address. And some of the trends that I would maybe emphasize here is what I just said. There's a multiplication of non-state armed groups, which pose for us also significant operational challenges, and also a diversification of these groups. And that was one of the things that Marco mentioned, that we have not only traditionally hierarchically structured armed groups that in a way mirror the organization of state militaries, but we also have increasingly more horizontally organized armed groups, which have a different command structure and in which maybe commands are not so much given from top down. And we also have community embedded groups. And for all of that, the question that is posed to us is, how do we best engage with them? And how can we best achieve that these different types of armed groups actually put restraint in their behavior, respect IHL, and act in accordance with these very basic principles? And here I can only recommend to all of the listeners a study from, I think, 2 years ago. It's called Roots of Restraint in War. It's an ICRC study conducted in different operations in different states and different operations with non-state armed groups to see how can these different actors, states, different types of armed groups be influenced in order to better respect IHL. And by influence, we don't mean necessarily external influence, but also how they can internalize IHL, especially states. The other big trend that I would see, or that we observe when we look at the various parties to armed conflicts that we have, non-state armed groups, parties to armed conflicts, is that many of them work actually, or they are to some extent supported by states. They operate on behalf of states, or they receive support by states. A significant number of them does. So we have this phenomenon of proxies. And actually, non-state actors as proxies cannot only be non-state armed groups, it can also be private military and security companies that operate in conflict settings on behalf of states. And here, of course, we have to engage with these actors directly, so with these non-state actors, and engage them to see how we can also help them to respect IHL, to implement IHL in their operations. But also, and that is when I say that we see a lot of states supporting them, is also a question of how do we engage with the states that actually exercise support or even some control, some support over these groups? And how can we leverage this influence by states on armed groups in order to work towards better respect for IHL? I think that is a significant task we're facing, that we've faced over the past years, but that is also one that will continue in the coming years.
Thanks a lot, Tilman, for sharing these thoughts with us. Indeed, to the multiplicity of non-state armed groups, I think there is also another issue, which is jihadist infighting that we often don't necessarily look at, actually, but that also poses quite interesting challenges. Now I would like to give you the opportunity to discuss with each other before opening the floor to questions. Everybody is bearing with us from the beginning of this discussion, so this is great. Thank you everyone for your engagement and on the chat box. Don't hesitate to add your questions, and I will soon open the floor to questions from the audience. But first, if any one of you is interested in sharing some thoughts with one another, here is the opportunity to do so. Ezequiel?
Yes, thank you very much, Rebecca, and thank you, Marco, Tilman, and Yasmin for the interventions. No, I thought they were excellent, and they gave a lot of food for thought. I mean, I have actually one comment and one question, actually, one thing that I have in my mind to discuss. I think very quickly on the issue of lawmaking by armed non-state actors. I mean, we have discussed this already before many times, but I think it's very interesting because, yes, in terms of, again, formal lawmaking processes, I think it's quite challenging to say that armed non-state actors can, again, even if we go to the definition of treaties in the Vienna Convention, it says that it's between states. There might be other agreements outside of the scope of the Vienna Convention, but it's complicated in terms of formal lawmaking processes, selecting groups for customary norms. But there might be other situations of law, I would say, lawmaking or norm developing that armed non-state actors are part of. So I mean, I could say the deeds of commitment that Geneva called that it's one example, but then even I remember that for the additional protocols, national liberation movements were invited to the diplomatic conference, even if they couldn't vote for it. For the content, or they couldn't ratify that. I mean, of course, as Yasmin mentioned, the Wars of National Liberation of Article 96 of AP1, but there might be situations or certain examples in which armed groups were at least consulted for certain tools. So the other example is, for instance, the ICRC in 2015 did a study on healthcare and on armed groups, and in which it includes a unilateral declaration, and there were armed groups that actually had been consulted on this. So I agree that formally speaking, it would be challenging. Informally, I think there might be other alternatives. On Yasmin, I think it's very interesting, and I think it's one of the examples in which it is kind of like certain. I mean, it is being accepted the role of non-state actors. How actually international law is being pushed, you know, the boundaries are being pushed. So traditional state-centric international law is being pushed to include other entities that may have an effect in the international arena. So this is why in all circumstances, and by everyone. And I have that impression that was one of the examples. I mean, in terms of customary and customary law, treaty law, and also the role of other institutions dealing with this issue and trying to involve non-state armed groups in the discussion. And a point that I always thought it was interesting and from Tilman's presentation, but you know, the role of the ICRC is, in the end, the IC is a non-state actor by nature. So you have a non-state actor actually is the guardian of IHL and is the one in charge of doing conflict qualification and engaging with other non-state actors and state actors as well on implementation on respect of IHL. Yeah, so that's it from my side.
Thanks a lot for this. So except if you have a burning issue that you want to share, I will open the floor to questions from the audience. So I see you nodding. So this is what I will do now. So moving to the issue that I mentioned before to you, Yasmin, and in terms of accountability mechanism and judicial review, we have several questions in that regard. So one of them relates to the role of the ICC that you mentioned at some point when we discussed together. So do you view the ICC as being able to prosecute a non-state actor, either for specifically the use of chemical weapons, but for other situations as well, and even in peacetime? And then there is another question, taking the other side of the coin, from a colleague from Leiden University, Helen Duffy. She's pointing to this growing phenomenon of the establishment of criminal justice mechanisms by non-state armed groups. For example, she asks, do you see potential implications for the development of the law, practice of cooperation between states and non-state actors, engagement of human rights bodies, or just more generally in influencing the dynamics around these issues? And Yasmin, maybe you can start, and then if someone else has some thoughts on this.
Sure, thanks for the question. On the ICC, indeed, as I mentioned, under Article 8 of the statute, there is the possibility to prosecute an individual for use of poison weapons or use of gases. Now, the question of why that seems straightforward arises because of the drafting history of the ICC statutes, because in fact there was a whole discussion of whether or not it should include chemical weapons as defined in the Chemical Weapons Convention. And if you look at the language used in the Rome Statute, actually they ended up using the language of the 1925 Geneva Protocol, which seems a bit weird. And the reason for that is because the nuclear possessor states were not really happy about having a kind of catch-all provision within the Rome Statute that would ban whole sort of categories of weapons. And sort of as a response to that, some other countries which are not possessor nuclear states, who sort of view chemical weapons, if you like, as the poor man's weapon, as I began my presentation, say, well, then we're not going to have chemical weapons in there either. So you ended up having this situation of both being taken out. And in the end, the compromise was to have the Geneva protocol language in there. So it begs the question now of whether or not that inclusion of that language within the Rome Statute would actually cover chemical weapons as defined in the 1993 convention. And there is a few arguments to say on either side. It hasn't been tested in court yet. But looking at the literal language there, it would be hard to imagine that there would be chemical weapons that would not be covered by the language used in the Rome Statute. Now, that of course deals with war crimes. There's of course also the provision related to the prohibition of, or the crime of using weapons causing unnecessary suffering and superfluous injury. But that provision, first of all, is dependent on the eventual adoption of an annex to the convention that would list specific weapons that would apply to that general provision, which hasn't happened yet, and is also found only in the part of the Rome Statute dealing with international armed conflicts. So again, difficult to imagine that that could be used for non-state actors. Now, there are other provisions of the Rome Statute that could apply, crimes against humanity, the provisions on that if there was a use of chemical weapons which was committed in the context of widespread or systematic attack on the civilian population, and it amounted to one of the constituted acts under crimes against humanity, then indeed there could be use. And there you can see that that could be, for example, one use of a chemical weapon within an attack using conventional weapons. That would still probably amount to a crime against humanity, or a repeated use of chemical weapons also within the context of an attack on the civilian population could also amount to a crime against humanity in the language of the Rome Statute, in my view. Now, as we know, crimes against humanity, they do have to be in that context, but they don't necessarily have to be done, committed in the context of an armed conflict. So there, in relation to that second part of that question, in these circumstances, you could say, yes, well, if a crime against humanity is committed in peacetime, then indeed, this would be a possibility. Also, the crime of genocide potentially could be committed in either armed conflict or in peacetime if a chemical weapon was used in a manner causing one of the prohibited acts of genocide with the specific intention of destroying in whole in part one of the listed groups. Then again, you could indeed have a prosecution against a non-state actor for genocide, both in peacetime or in armed conflict. And in fact, there have been prosecutions, not of non-state actors, but certainly there was the case of the Zyklon B case before the British military court following World War II, concerning the use of the insecticide Zyklon B as a means to exterminate people in concentration camps, and 4.5 million people died as a result of the use of Zyklon B in concentration camps during World War II. So there was also prosecution for genocide before the Iraqi Special Tribunal, and there a conviction for the use of mustard gas against the Kurdish population, which resulted in conviction on genocide in terms of the use of chemical weapons. So those two aspects, there is again another source of international law which demonstrate that non-state actors could be bound by customary international law related to the use of chemical weapons. I'll perhaps leave the second question, which I think is probably more appropriate for our other colleagues to answer.
Thanks a lot for this very elaborate answer on the question. Is someone willing to answer the question on how you see the establishment of criminal justice mechanisms by non-state armed groups? Marco?
Well, I mean, this is a good development, and it's even an obligation under humanitarian law to prosecute their own members who have committed violations under command responsibility. It is obviously also complicated in particular, if we believe that non-state armed groups are bound by human rights law, because it's not easy to respect human rights, in particular the principle of legality, when prosecuting by an armed group. But I think there can be a solution now. Helen has suggested cooperation with states. Well, I don't see them states cooperating, and I must say recent experience I have had concerning the foreign fighters tried, or which the Kurdish groups in northern Syria tried to prosecute Western states, of which these foreign nationals were very reluctant to even implicitly admit that there could be criminal prosecution by an armed group. And the problem is, obviously, once these people would be repatriated, they would have to be released, because under the law of no state in the world, the penalty could be executed if it was pronounced by a non-state actor. So I think there is still a lot of a road to do to bring cooperation between states and non-state actors, especially in the field of criminal justice, because in other fields it's easier. At least if you are allied with a non-state actor, while in the field of criminal justice, this seems to me is seen by states and by human rights law still as something incredibly reserved to states.
Thanks. Tilman, I think you also raised 2 fingers.
Yeah, but that's the unfortunate position of speaking after Marco. There's not there's not so much that I can add. Marco touched on the points. It's foreseen by IHL. IHL sets a framework for trials for all parties to a conflict. That necessarily means it also sets a framework for trials by non-state armed groups. It's really challenging to have that implemented in practice, but I would caution against the idea that it's impossible. There are practices by armed groups. No, I wouldn't say that there are armed groups that have actually set a good example of how to do it, but there are ways, as Marco also hinted to, of how these IHL obligations, especially under AP2, of what a trial needs to look like, can be implemented. And here I see the reality that Marco points out to, but there's also the reality that states that are partnering with armed groups and are supporting armed groups, they have an obligation to also ensure respect by these groups. And so as much as it might be an uncomfortable political decision on whether you work with armed groups on trials or not, it is something where you might have an obligation to do so.
Yeah, interesting. Moving on now to another set of questions. I'm grouping them together in light of the time that we have left. So sorry if these questions are now anonymous all of a sudden. Quite a lot of people are interested in what you mentioned, Marco, on the application of jus ad bellum. Jus ad bellum and jus in bello concomitantly, and are looking forward to hearing more about this. So could you elaborate on, I think some questions are interested in how it can interact and why it should interact in your view, if you can further this.
Well, for the benefit of my students, I would say don't interact, but we need both, but they shouldn't interact. But we need both. And my comment was simply that for non-international armed conflict and for armed groups, we don't have a jus ad bellum. And this has a negative effect in the sense that while in international armed conflict, hypothetically, a state could perfectly be an aggressor and then perfectly comply with IHL, and therefore no one has committed a war crime, but nevertheless an act of aggression has been committed, and this is condemned by international law. While in a non-international armed conflict, an armed group which fights to get control over natural resources and to deposit a democratically elected government to establish a dictatorship is treated in exactly the same way than an armed group fighting for the population against a dictatorship. And because there is not this necessary pendant, which is jus ad bellum, and therefore we have only, which is important, obviously, rules on how to conduct the war, but we have no rules on when is it legitimate to start a war. In my view, the government can never start a non-international armed conflict, but it is only a non-state actor which may, in certain situations, start. The government will only be able to react because under human rights law, it must, as long as possible, try to use law enforcement methods.
Many thanks for this. Yes, Yasmin.
Just an additional point on this one. One of the interesting parts of practice looking at Security Council resolutions was, of course, in the aftermath of September 11, when you had for the first time the Security Council recognising that a non-state actor could commit an armed attack and thereby trigger the right to self-defence by a state. And that sort of initiated, in my view, a new idea that not only certain acts of terrorism could be a threat to international peace and security, but also this jus ad bellum aspect of self-defense by states against non-state actors, which previously was something that was really only in the realm of jus ad bellum between states. And I think that has also sometimes generated some confusion between this right of self-defense by the state and indeed whether or not the obligations of international humanitarian law are going to be applying to that conflict. And it's something that has come up in a number of cases in non-international armed conflicts. I know specifically at the ICTY, in which the appeals chamber has had to sort of reaffirm that separation between the jus ad bellum and the jus in bello. But I think we've witnessed something new and interesting in international law, which is of course still controversial. The idea that in fact a non-state actor can commit an armed attack. And again, going back to this idea of this elevation, if you like, of acts of non-state actors to the level of states is something that's definitely notable and perhaps has created some confusion.
Thanks, Yasmin. I would like to give the floor to Manuel, who has joined us. He was with us from the beginning, but we can see him now. Manuel?
Thank you. I didn't want to scare off anyone with my face, but now that I'm here, I just wanted to raise a point about the jus ad bellum issue. Of course, Marco is entirely right that at least under international law, formally there's no jus ad bellum vis-a-vis non-state armed groups initiating civil war, unlike states. But just in that context, in that particular context, it's interesting to note that, of course, that's the position under international law. But under domestic law, on the other hand, you certainly have a number of states that seem to recognize, to some degree, that a right to rebellion under their constitutional law. And there are a number of states around the world that include this specifically in their constitutions. Germany, I know, is one. I think Greece is another. And a number of African states from around the world have a specific provision in their constitutions. Germany, you can understand why, I think, but certainly other countries as well. So this idea that there's no jus ad bellum international law, fair enough. But like I said, interestingly, at least states seem to suggest that, at least for themselves, might not speak to other countries, but the idea that states don't try to avoid this granting this sort of right to non-state armed groups to do this might be right as an instinctive reaction to that. I mean, what country would allow non-state armed groups to commit such acts? If you dig a little bit deeper, it's not necessarily the case. To be fair, it's not a majority of states that have these in their constitutions, to be sure. I do have the numbers there. I wrote something on this some time ago in light of the Malabo Protocol, which interestingly has the crime of aggression. This is for the African Court of Justice and Human Rights that's envisaged by the African Union. Among one of the crimes that they have in that statute is aggression, the traditional aggression, so to speak, where you have a state violating the jus ad bellum. But in that provision, there's also the crime of aggression that can be applicable when non-state armed groups initiate armed conflict. So at least for the African region, you have this explicit in international criminal law sense, you have this explicitly put in. And it was in light of that I decided, well, that's a bit odd for the jus ad bellum. So, I was digging in and I found that, there's a number of states that have this in their constitution, including Africa. So I think that's something to bear in mind, in these sort of, when discussing this particular matter and non-state armed groups.
Thanks a lot, Manuel. I feel that we already went over time quite a lot. There are still a lot of questions. So I want to share with you an email address to which you can send us your question if you can identify specifically the speaker to which to whom you want to address your question, and then we will make sure to forward it to the person in question. I want to thank you all again for your excellent for this excellent discussion, but also all the participants, the attendees for their excellent questions, and you all for your elaborate answers. I want to make sure that Frank Becker has the few last words. He's the publisher for T.M.C. Asser Press. But before giving him the floor, on behalf of all organizing institutions, I would like to thank everybody for coming virtually to the Asser Institute tonight, and in particular, of course, to you all. I want to also to thank my colleagues Eva da Costa and Stephanie Morland for the organization of this event. More lectures will be organized by the Asser Institute in the forthcoming weeks and months, as usual, so you can just check our website, or you can even sign up to our mailing list. We have on the 26th of November our annual lecture with Professor Andrew Murray on law and human agency in time of artificial intelligence. Frank, you're still with us behind your screen. You can now turn on your camera, and the floor is yours.
Thank you, Rebecca. I tried to start up the video, but nothing happens. Maybe the conference manager can do something. Anyway, yes, start my video. There I am. Thank you very much. Yes, thank you, Rebecca. This is a proper book launch, although it is via Zoom. So I find it proper as a publisher that I show the book. Well, here it is. And as you can see, it's quite voluminous. It's, it has more than 450 valuable pages. And therefore, of course, I'd like to congratulate the editors and the authors. It's an innovative publication, and I thank them for their patience in the production process and possibly the sweat, toil, and tears they have put into all this work. And of course, dear editors, I look forward to book number 2, as Professor Marco Sassoli suggested. May I invite you in the audience, every one of you in the audience, to visit the info page of the book on the Asser Press website, where you can find an offer for a discount on the list price. It's now up to you, the readers, to explore the richness of this edited volume. And always remember what Edmund Wilson wrote: no two persons ever read the same book. Okay, wrapping this up, this very interesting evening, I'd like to thank the speakers for their contributions, my colleague Rebecca for moderating the event so well, and I thank you, the audience, for your presence, attention, and participation, and I hope to see you again at one of our events in the future, in person or in cyberspace. And in these troubled times, of course, I end with keep safe and goodbye.